Supreme Court has ruled in a 4-4 decision regarding the funding of religious charter schools. Justice Amy Coney Barrett recused herself from this decision, so the case now goes back to a lower court. Senior Washington reporter Devin Dwyer joins me now for more on this. And Devin, first, can you break down this case? And also, how rare is it for a justice to recuse themselves from a case?
Well, this is a very significant case, Alex. This was a case that could have established for the first time a taxpayer-funded religious charter school in the United States. This is a case from Oklahoma. A Catholic school, St. Isidore of Seville, applied for a charter from the Oklahoma Charter School program to be funded as a religious school, teaching Catholic doctrine, including church services and the like. It was challenged in court, and the state's highest court struck it down as a violation of the Establishment Clause of the U.S. Constitution and the state constitution. And what the Supreme Court said today, Alex, is very little. They were gridlocked 4-4 in this case, and that means the state court decision will stand in this case, blocking any sort of order, at least at this point, creating religious charter schools nationwide. So a significant development, a setback for the religious freedom movement, a sigh of relief for charter schools and public school advocates who had really feared that this would have opened the floodgates to dramatic changes for these programs. And all of it really comes down to the vote of one person, and that's Amy Coney Barrett. The justice, who is herself Catholic, recused from this case early on because presumably, although she didn't explain it, she has close ties to the University of Notre Dame Law School where she used to teach, and that university was closely allied with the Catholic school in this case, seeking to become a religious charter school. So she sat this one out, and that led the Supreme Court to be deadlocked. It's not unusual for justices to recuse themselves when they see conflicts of interest, nor explain themselves. She did not explain herself, but many watchdogs are telling us today, Alex, that they see this as a positive development, that the Supreme Court is abiding by its ethics guidelines. She stepped aside when she felt that she would violate impartiality in this case. But a major ruling simply because the court couldn't come to a majority agreement, and one of those conservative justices, we don't know which one, joined the 3 liberal justices, presumably, in blocking this case from moving forward, Alex.
Yeah, so interesting. Well, and Devin, one of the things that every analysis of this decision that I've read thus far is saying that eventually a case like this will come back before the Supreme Court at some point. How could it be different next time?
It's a great question. Because the Supreme Court didn't issue an opinion here, they really only gave us one sentence saying the Oklahoma court's decision will stand. It is not a binding nationwide precedent. That opens the door for a future challenge. Many of the same facts could be presented, frankly. But advocates for this type of arrangement, religious charter schools, will now likely be looking for a different state, a different setup that could come back to the Supreme Court with hopes of getting all 9 justices to weigh in. We don't know whether Justice Barrett would sit out a future case or not, but the facts are, Alex, from everything I've heard and read, that an attempt will be made. So this isn't the final word. You're absolutely right about that.